for inclusion in the list, admission of appeal.
Your Lordship, in your last order, my date was supposed to be on 21st of this month. I asked the gentleman here, when will be the next date? He said today. Is not there today. 1 year has passed and the accused is misusing his liberty. I seek a early date.
Is this a assigned matter?
This is yes, it was assigned by the Chief Justice to you, Your Lordship.
It will come up on the list.
Thank you.
Next month, it will come up.
My lord, may I be permitted to mention a matter, my lord? This is an application planned to, my lord. My lord, the applicant is in custody for more than 14 years, my lord. The conviction has been given. It was earlier.
Well, I'm mentioning one appeal hearing, my lord. It was, my lord, in the list, my lord.
My lord, may I be permitted to mention one matter? The matter is pending. The petitioners are in custody from 2015. However, they were in parole for 1 year in 2021. But again, from 2022, by the order of the state of this honorable court, they are again in custody. Therefore, I am praying for inclusion in the list. I'm grateful.
What is your side matter? Specially fixed matter. Item number 1.
Millard, this is my appeal, Millard, arising out of an order passed by the Honorable Single Judge, Millard.
Praying for 1 day accommodation.
May I just say 2 words?
Well, only 1 day
Millard,
accommodation.
arising out of an order passed by the Honorable Single Judge, Millard, whereby my application, Millard, for asking for a decree for non-compliance of an order passed by the Supreme Court, Millard, which was, Millard, which Millard modified, Millard, the order of the Single Judge, Millard, was, Millard, not, Millard, complied with.
Now, today, what do you want? Today, what do you want?
Millard, today is fixed for hearing. That's the reason I came here. Millard.
Only 1 day accommodation. Well,
It will take time. We cannot fix it. We cannot do it today.
Yes, yes.
I leave it to your Lordship because it was under the heading specially fixed.
Correct.
That's all. It has to be heard out, Millard.
What is the where is the order impugned?
Millard, if your Lordship takes the
Page 86.
page 86 is the order impugned, Lordship.
87.
87, Millard. 87.
Concluding portion.
And the concluding portion, if your Lordship kindly have a look, page 98.
98?
The proceedings arises out of, Millard, an act.
98. Please, the order.
Page 98, Millard.
Chapter 13. Supreme Court. 66.
So, there's a modification of the conditional order.
Yes, conditional order. They have not complied with the condition.
Now,
Millard,
the question is the conditional order, according to the learned single judge, stood modified by the Supreme Court. And therefore, it was not a conditional leave to defend.
Yes. Against that, I mean, appeal.
So, we'll consider that.
Yes, absolutely.
After vacation? After vacation.
Lordship.
Let the matter appear on, we take it up on Fridays. So,
Very
give
well.
us
Any date after vacation.
agree and give us a date. We'll give it.
Any day convenient to Lordship. After vacation, any day, my lord.
Huh?
Any day, my lord. After vacation.
So, we keep it on 10th of January?
10th of January.
10th.
In the meantime,
4 lakhs was reduced to 2 lakhs as a conditional leave to defend. That's
Whether the condition that failure would amount to an automatic vacation is to be considered.
Absolutely. That's the only point.
Because the single judge said that
It's not a condition, Millard, for
the
defense.
condition incorporated in the order challenged with the Supreme Court was not retained by the Supreme.
That is, my lord, that is what he has
So
said.
that is so. A plain reading of the Supreme Court's order does not retain it, does not retain it.
No, we are merely reducing the amount from X to Y. That's
Chapter
all.
13.
Chapter 13, Lordship knows conditional leave to defend,
Right,
that is
right.
embedded there. That will be my argument.
We'll just
Great.
place the order of the Supreme Court in light of the facts and facts.
Very well. Grateful. Much.
In the meantime, trial is going on.
ठीक है. Great.
এই তো স্পেশালিফিকেশন कोई হেডিং এর আবার কি? Reduce Krishna has said that they have not reiterated the terms. But take no offense. Next,
Appellate side matters. Item 1.
1, 2, 3, and 5.
One, I appear on behalf.
One second, you need not appear anything. Corrections be made. Call for.
Grateful, my lord.
Maybe 6 or 6.
Item 4.
Okay, I put the petition on also. In paragraph number 4, Lordship. Instead of Chief Judicial Magistrate,
Correction, correction. Yes,
CJM, Sialda.
yes, allowed. Next,
Item 5. Six.
I'm for the appellate in item number 6.
তোমার ওইরকম যে কটা আছে
Nine, 10, 11, 12.
So 9 to 12.
12 correction.
Yes, my lord. Huh?
Yes,
তোমার ইয়ে
13.
কেস নাম্বারটা বলছি
Yes.
13, 14, 13 to 21, I am for the appellate. Then 13 to 21, then 26, 27, and what are they? And 30. The 30 for us. 30 for us.
13 to 21.
30, but item, but item number 13 to 21.
Hmm.
Then 26 and 27. I am for the
22,
appellate.
23, 24 and 25 and
For
27.
extension of interim order, my lord.
You are 22, 23,
24,
24.
25, 27.
27 amount.
He is 27.
I am
Can I have this?
Then 28.
I'm
You know,
for my lord, 22, 23, 24, 25 and 28, my lord.
all right. Appellants seek extension of interim order. Nobody appears for the respondents. Interim order is extended for 3 months or until further orders, whichever is served. Matters are ready for hearing.
is ready for hearing.
for
This
hearing.
matter with regard to declaration of vacancy by the whether existence of 2013 control order after promulgation.
Let us, we will place this matter if necessary. After vacation, liberty to
But
mention.
probably my lord, Contempt is
Contempt is pending next week.
Next week is contempt is coming next week
So when the contempt comes, we will fix the hearing of
as
this.
well. Good.
Yes, next matter,
29.
29. Not today. Not today. Nobody appears, adjourn for the day.
Not to.
30th.
But so for item number 30, madam,
I appear for the appellant, my lord. The interim order has been extended till 30th. And another thing is, the state was required to file a report pursuant to your lordship's direction.
7th October.
7th October. Pursuant to your lordship's order on 7th. My lord, what I would be praying, my lord, if there is a direction upon the state to serve a copy of the report, because
They have
File
not part file report.
Filing
they were required to file a report, my lord.
states my paragraph 5, madam.
State is directed to file.
Yes, madam. By the
report.
director, not by
By
the
the-
rank of
Ah,
joint director.
Joint directors.
report, affidavit.
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 Affidavit is,
Affidavit in opposition.
state shall submit affidavit positively by the adjourned date, if not already done. Copies be served upon the appearing parties in the meantime. Matter will appear 2 weeks hence.
Lordship.
Interim order is extended till 31st January 2020.
Lordship. I'm grateful.
For
আমাদের নাম দিয়ে দিয়েছি দিচ্ছি কাগজ
Next.
এ নয় I'm grateful, madam.
Yes, Mr.
For the response.
We know there was mentioning nobody is appearing. Could you give a notice, Mr. Ali? Suddenly it has come.
No, my lord, I'm in a very difficult.
What difficulty it is?
Particularly, your lordship will kindly recall, my lordship is appointed a special officer.
Correct. We need that report.
Yeah.
Nobody is here. Nobody is here.
We have given my lord and we have taken an exception to that.
Report has been filed.
Because I believe it has been filed. A copy was given to us.
Correct.
We got the copy and we took an exception.
Very good. Very good. So we will have to hear it.
But
We will
that-
have to hear it. Nobody is appearing today.
No, but that is not the problem. The problem is, my lord.
Tell us the problem.
A democracy soul is hanging up on my door. Here the dispute is, well, in the original petition, the dispute was whether the lease was for 10 years or 30 years. This petition is pending. And before the lease court, my lord, my learned friend opposites gave an undertaking. Our demand was that the undertaking has been violated. For that, a contempt proceeding. In the contempt proceeding, my lord, there was an order for status quo. In that status quo, against that order of the status quo, though the contempt was not held. But against that order of the status quo, disappeared, which is not before you know. The point of determination is as to whether there was a contempt or not and whether the undertaking. That apart, when I make my submission. But in the meantime, one day thought that we are in unauthorized and an eviction proceeding has started.
That you have to pray for a fresh application.
We have.
Application for staying the
That application is pending.
that before the trial.
No, that application is pending. Because the matter is pending here.
No, that has will make it clear. You proceed. Yes, Mr. Chaturvedi, you have filed your report.
Look, the report not has circulated. I shall file it.
You shall file it. That is what he has not filed the report. Mr. Ali, the report has not been filed till now. Mr. Chaturvedi's report. Let the report be placed on record first. We don't have a copy of that. But we have the exception.
Please.
You are at liberty to assail the eviction notice in the writ proceeding or in any independent proceeding.
My lord, the plight is, my lord, so far as the eviction proceeding is concerned.
That is independent of this.
My lord, rightly, wrongly, an application has been filed before you. That application has also come up along with this application.
Which application?
Pardon, my lord?
Which application?
That is can do.
We are saying can do, we are disposing of giving you liberty to approach the trial judge.
But in the meantime, my lord,
This is an independent cause of action, nothing to do with
my
the
lord, what happened, I am telling you. What you can give me a second. My lord, it is the eviction of, I mean, the state officer. The state officer. My lord, he is behaving in a very, very undue manner with my learned advocate on record. And he is under a threat. We are under a threat that I am going to pass the final order on this Monday.
All.
And my lord, one of the contempt respondents, my lord, here, one of the contempt, but he is on head of this state officer, and he was forcing and he acted in such a manner, my lord, which I'm not going to disclose in the open court.
Look, from the proceeding, there is an alternative remedy, my lord.
You know, alternative remedy is not always a bar. Yes, it is not always a bar.
The thing, Mr. Ali, is
My lord, I would plead, my lord. I
yes,
would plead, my lord, your lordship will kindly take the objective view of the entire matter. So far as the issue is concerned, my lord, the main issue is pending in the writ proceeding. And here also it has come, my lord, as to whether the undertaking has been violated.
My lord,
that is the limited area which we are considering.
Lordship will give me, my lord, only 2 days.
my lord, I'm appearing on behalf
what?
of the appellant.
So that he doesn't, my lord, stay in his hand.
No,
He does
Mr.
not proceed.
No, Mr.
My lord, even if it's
My
not
lord,
an
I'm
official order.
appearing
No,
on
Mr.
behalf of the appellant.
Where is your can? Let us see your can.
Can,
My lord, I'm appearing.
can is there.
My lord, my lords,
Thank you.
my lords,
Thank you. It is a parallel proceeding. For a moment, your lordship will kindly see paragraph 9.
my lords, my lords, I'm appearing on behalf of the appellant. My lord,
report দিয়েছে
my lord, I'm appearing on behalf of the appellant. I'm led by Mr.
কি বলছে
Advocate Mitra, my lord. May I take a short passover?
no no we are for the appellant what he said
আমার নাম করছে
আমি তো জানি না কি করছে
কি
আমি জানি না কি
আমার নাম নয় কিন্তু
হ্যাঁ হ্যাঁ আমাদের মামলা
তুমি তো
appeal from the order of contempt order of contempt orderটা করলো তখন বললো যে contempt কি হয়েছে আমরা অ্যাপিলটা করলাম আমার অ্যাপিল আমি অ্যাপিল এবার আমার অ্যাপিলে এবং কন্টেম্পটে ও অ্যাপ্লিকেশন করে আমাকে এখন দিচ্ছে যে স্টে করো এভিকশন রিপোর্টটা কিছু বলেনি বলেছে শুধু ক্লোজ প্রক্সিমিটি আছে ইটস নট দ্যাট আই এম এনক্রোচিং অন দেয়ার ল্যান্ড সেটা বলে
দেখেও নি রিপোর্টটা
আমাকে তো রিপোর্টটা
বলেও নি কিছু
এই
রিপোর্ট দিয়েছে
হ্যাঁ রিপোর্ট দিয়েছে
কখন দিয়েছে
হ্যাঁ বলো অন্যদিন একটা রাখতে
I thought just
Mr. Mitro,
the report has been filed. I thought
report is filed. We
I have
will,
not.
will circulate one thing. What Mr. Ali is indicating to us is the undertaking was given. Whether the undertaking violated or not is another thing. There is an order of status quo in respect of the 5 plots.
That's been stayed by the appeal court. That's been stayed by the appeal court.
That has been stayed
Stayed
by
by
the now in the
the appeal has to be heard. Appeal that is there's a stay of that in the appeal court
there's a stay by the appeal
by the Honorable Chief Justice. That is the order of
And in
2nd
the-
January
In
2024.
the meantime, the estate officer has initiated proceedings for eviction of Mr. Ali's client.
Yes, so that was made clear even before the learned single judge that by due process of law I shall be evicting him. That was made clear before the learned single judge. My undertaking was I shall not dispossess them by force
But,
and put somebody.
That is not the undertaking.
One second.
Please.
Yeah, okay, could you place the order?
Lordship kindly keeps it. Lordship kindly
That's
keeps
not
it next week any day. Because
We have no difficulty, but at least don't pass any order. The estate officer should not pass any order.
Lordship, it's only that the summons has been issued. So
So that is what we are saying.
Lordship, please
What
not
we-
say that nothing will.
Let us be very clear, Mr. Mitra. We would give, because we are also not in session. Today, our special officer has submitted the report because it has come up. The last occasion when we took up the matter, this is the first time it has come
Lordship,
up before
kindly
us.
this is the order in appeal, my lord.
Mr. Mitra,
passed on
what we
2nd
are
January.
saying is, we will fix this matter, let us say, on 13th of December, right? So before that, no order should be passed.
Lordship kindly here. Lordship kindly, because this was exactly their submission before the first court. First court did not allow. Lordship kindly sees the orders once. Well, Lordship kindly sees the order firstly of the honorable division bench. Lordship, honorable division.
Mr. Ali, we do not appreciate intervention.
Order copy টা করে দাও, তুই
Let
চেয়ে
him
আছিস
make
কোথায়
his
কেন?
submissions.
order টা কোথায়?
We will
না, না,
go
না,
back.
order না,
Prefer,
orderটা।
তাহলে ক্যানে দেখো
that is,
Your lordship knows me.
and so why are you breaching your culture?
I'm breaking it because
Page
when I
19,
find
page
that a colleague of mine
Ah,
completely, my lord,
misleading us, right? Our problem.
Fine.
We will take care.
I am just taking my.
We will take care, Mr. Ali.
I do, my lord.
Please sit down.
My lord.
Please sit down.
Yes.
We'll revert to you before we pass any order. Don't worry.
Lordship kindly sees page 19 of the can 2 is the order of the learned page 19.
Right.
25th September 2023. Lordship kindly comes to internal page 5, running page 23. Running page 23, that is the order which is there, which has last paragraph is my submission page. Mr. So-and-so then submits that cite unqualified term that the lease granted to the petitioner was for 10 years.
Yes.
However, it is submitted by him that the tender in question does not involve the land sites and 5 numbers of weighbridges for which lease was granted. By the impugned tender, interest of the petitioner will not be hampered, and SMP Kolkata shall take necessary action for removal of the petitioner in due process of law. Now see the undertaking, last page, page 27.
Yes.
Second last paragraph. Since the learned advocate on behalf of the respondent SPMP undertakes that the tender process does not involve the land sites and 5 weighbridges for which lease was granted to the petitioner, this court, relying on such undertaking, does not think it necessary to pass any interim order at this stage. This is the now Lordship kindly sees the next comes the order under appeal, which has been stayed by the Honorable Division Bench. Page 29. Page 29. Kindly come to page 33. At the bottom of 33. After hearing the learned senior counsel for the parties and upon perusal of the materials on record, this court is of the firm view that the order dated September 25, 23 was passed inter alia clearly on the basis of an undertaking as recorded in the penultimate paragraph at page 42. That is the paragraph which is page 27. Page 27. Now, Lordship, page 27 bottom. After recording, I shall be taking steps by due process of law. Now, Lordship kindly sees. Now, Lordship kindly comes to the operative part, page 35 of this order, which was passed by the learned single judge. Second paragraph. In view of the foregoing reasons and discussions, this court is of the firm view that the parties shall maintain status quo as on 25th September over and in respect of the said land sites and the 5 numbers of weighbridges to the extent of the issues and subject matter involved in the interlocutory application being can, insofar as the subject matter, insofar as the subject tender is concerned, which is also subject, whatever that means. Now, Lordship kindly comes to the appeal court. Whatever, because it's in contempt, kindly see the order passed in the appeal filed by me. Lordship must be having copies of the 2nd January order, my lord. 2nd January order, Lordship. I have a copy. Lordship kindly takes a look at the 2nd January order, Lordship. Two pages. I'm not placing. I have only one copy, Lordship. Kindly take a look at it. Pending and disposed of it. Pending and disposed of it.
No, it is pending. It is pending. It is pending. Confidential. What a scope of appeal, whether there was a contempt or not.
Right. So, my submission is most humble submission. The scope of the appeal was whether they in violation or not. There was some kind of a status quo order passed in the that has been stayed. So, if they want any further order, the petition is pending. They can't come in my contempt appeal and ask for interim order. This is my respectful submission. And Lordship, so far report is concerned, kindly let that be circulated. Lordship, as I was saying, Lordship keeps it. Oh, I have, but I'm taking. I have not seen the report. Lordship kindly keeps it, and he did this maps. But may I must kindly, I was.
No, no. I'll understand that refer to page 27. Where is this correct? Since the learned advocate. Since the learned advocate on behalf of the respondent undertakes. What is the undertaking? That the tender process does not involve the land site. Now, my question is, what is the land site? What is the land site that has been given to me? That has to be determined. 5 bridges for which lease was granted to this petition. This court, relying on such undertaking, does not think it necessary to pass any interim. How does the court was trying? The court was given an impression, your lordship will kindly now take that order of the writ court. The matter is pending before the writ court as yet. Affidavits have been exchanged. What was the from that order, a particular submission of my learned friend I will show.
Already placed.
Lordship kindly goes to page 23 of the writ court order. Mr. Mitro, at the bottom, page 23. Mr. Mitro, learned senior, Lordship got it, madam. Learned senior counsel appearing on behalf of the SPMP Kolkata, on the other hand, submits that the letter dated so and so cites unqualified term with the lead granted to the petitioner was 10 years, however it is submitted by him. That the tender in question does not involve the land site, it is submitted. The court was given an impression that this particular land is not in any way affected by the new tender. By the new tender which they were likely to apply. Therefore, it is on the basis of this submission and, my lord, plus the undertaking. The court says, my lord, in page 27, in page 27, the learned advocate on behalf of the respondent undertakes that the tender process does not do the same thing. The submission as well as the undertaking. It is correlated. The trial court was given to understand that in any event that was his submission. Now my learned friend takes only this part, that the undertaking is this. Question of a submission, a solemn submission made before the court, the court was called upon to believe. Trust him. That was the order. That is my submission. Therefore, the court was implored. The court was insisted to believe him. That look, our submission is that we are not going to touch his. Not a question sometimes was raised. Are you the owner of the entire Calcutta Port Trust? No. We are not that cool to claim it. We have to stick to our particular agreement or the contract that is given to me. So also you have to. That is my submission. Then your lordship, my learned friend, has referred to page 33. To page 33. On page 33, only the penultimate paragraph of that page 33, my learned friend has drawn your lordship's attention to. But a little far, a little above. A little above. My lord, kindly seize, my lord. It is a very small, my lord. Kindly goes to page 30.
30.
Page 30. I would not be that intelligent to suppress this part of the order from any court. Being completely sincere and, I must say, honest to myself when I read it. My lord, your lordship, you can see. Mr. Obrojit Mitro. learned senior counsel appearing on behalf of so and so, on the other hand, submits that the letter dated November 20 cites in unqualified terms that the lease is granted to the petitioner for 10 years. However, it is submitted by him that the tender in question does not involve the land size. Again, that submission recorded by the court, my lord, where the contempt proceeding was taken up. By the impugned tender of interest, by the impugned tender, the interest of the petitioner will not be hampered. Shall take necessary action of removal of the petitioner. All right, will take, for which lease was granted to the petitioner. He then relied upon a petition, upon a portion from the order dated September 25 at page 39 to the contempt application, and submits that it was clearly recorded by the coordinate bench that by the impugned tender, the interest of the petitioner will not be hampered. Whether my interest is going to be hampered or not, who is to decide? It is certainly not the contempt court. It is the writ court before whom the petition is pending. But he is making a submission before the writ court. And all through this submission, it's not only before the writ court. I will show to your lordship the very same submission and the very same undertaking that also given before the court where the contempt proceeding was pending. And that was also recorded by the contempt court. So, my lord, then the paragraph starts, Mr. Mitra. Learned senior counsel appearing for the alleged contempt further submits on the instructions that the port authority has not acted.
Which page you are reading now?
Paragraph, page 33. Page 33. Page 33. Mr.
Yes.
Mitra, the paragraph starts. Learned counsel appearing for the alleged contempt further submits on instruction. Procedural kindly mark, on instruction that the port authority has not acted in any manner which amounts to violation of the undertaking recorded in the order dated September 25. And the work order has already been issued. Under the tender process is not in respect of the land sites of the files which are the subject matter of the pending writ petition and the interlocutory application. Mr. Mitchell and Son further submits that the contempt proceeding is not maintained. Very good. After hearing the learned counsel, and what is the observation of the bench? After hearing the learned counsel for the parties, and upon perusal of the materials on record, this court was of the firm view that the order dated September was passed inter alia
On the call.
clearly on the basis of an undertaking as recorded in that. It is recorded, what is recorded, my lord? Recording that it will not pertain to the particular five the places to which the deed was granted to. But on the basis of that submission, what it goes, my lord, it has been clarified in that order. Exercising jurisdiction in contempt, the court shall only look into whether any contumacious act done in terms of 2B of the Contempt of Courts Act, defining civil contempt. The definition of civil contempt inter alia includes violation of an undertaking given by a party before the court of law. The law is also settled. Contempt also lies even if a party attempts to circumvent the order of direction of a court will. The foremost principle while adjudicating a contempt proceeding should be kept in mind that the majesty of the direction as an order of the court should be upheld. The submissions of Mr. Oprojit Mitchell and the senior counsel appearing for the alleged contempt as recorded above would indicate that there was no violation of undertaking given by the port authority before the coordinate bench. He also reiterated, it is in bold letter, you have to see it. He also reiterated the same undertaking before this court as recorded above today also. Repeated undertaking given not only before the writ court, but also a court before whom a contempt proceeding was proceeding. They are also the same under that it will not in any way affect them, subject to the submission that the interest of the writ petitioner will not suffer. So taking together, my lord, this order was given. My lord, these orders After conclusion, my lord, the part for the status quo, my lord, my friend has shown that at page 35, he has referred to. Your lordship will interpret that. In view of the foregoing reasons and discussion, the court is of the firm view that the parties shall maintain an order of the status quo. The materials on record, the learned court has considered. Submissions also have the learned court considered. And thereafter, it says that in any view of the law of contempt demands that no party shall be allowed to circumvent or bypass any order of direction of the court. If it commends to your lordship, what has happened, whether the undertaking was to be read in conjunction with the submission made by the field before the court. That was the whole thing. Now this is an appeal. Your lordship is sitting upon the judgment of this appeal. The appeal, my lord, I am not going to make any submission at the present moment for the merit of the appeal, since they open it. As to whether the appeal dies or not, I am not going to raise all these questions. My lord, so in view of all this submission, all this made, my lord, thereafter, my learned friend also has referred to at page 37. My learned friend also referred to at page 37. Right or not? Yes. Page 37, this is the learned the Chief Justice is right. We are of the prima facie view that the contempt application was not maintained. Prima facie. The contempt application. So we entertain this appeal, and there will an order of status quo passed by the learned single bench so and so. That a status quo order was made in that upon a prima facie view. Is that a final order? All right, the question I am asking to myself. Now, taking into consideration of the submission, the undertaking recorded by the trial court, recorded by the contempt court, as well as considering even also by the learned division bench presided over by the learned Chief Justice, under all these considerations were taken. Thereafter, while this proceeding is considered, if the eviction proceeding is made, the final order is made, what remains about the petition? What remains about the appeal? What remains about everything? That means I am monarch of all I serve. Am I right? There is none to dispute. This is my submission, that is right. That is why, my lord, I am saying that your lordship will kindly give me a respite so that the damage is not done. Because I have been given threat, my lord, in a very, what should I say, in open court, it cannot be said. My learned friend was appearing, my learned friend. She was appearing there, and it is this gentleman. This is this gentleman behaving in a very, very nasty manner. I'm very sorry, I've never come up with this sort of a thing. But this gentleman, Kunta, look at one second. Yes. I'm not going to say this because it is not very honorable.
No, it's on not on record, Mr. Ali. Don't refer to things which are not on record. Not on record. No, there is nothing on record that lawyer was abused or anything. That is not on record. Mr. Ali, record is a record of a court.
It can take record everything.
Record is a record of a court.
I'm not saying it.
That is why, Mr. Ali, we cannot permit a senior counsel to blow hot and cold. If you rely, place on it. If you don't rely, don't refer.
One thing is there. Dil ki arma, kisko batao?
We are not comfort aunts. We are not comfort aunts. We are here to decide on forensic principles or as per materials on record. You wish to place that material, we decide on. If not, we understand your agony. But we have to restrict ourselves to whatever is before us.
But so far as we are here, we are human beings.
But we,
So the judges and the officials.
that is why we have to transcend human limitations. How can we feel sad about it, but what can we do? That is how you have created us. You, the people of India, we, the people of India.
Okay, what can we do? Your Lordship can do
The
everything.
people of India expect this out of us.
Your Lordship can do everything.
So we have to restrict ourselves to the four corners of pleadings. Thank you. Report of the special officer is placed on record. Exceptions to the report has also been placed. Learned.
I have not taken exception. my lord.
Exceptions to the report has been.
Kindly give me some time.
Anything about it.
That is exactly, but I have to record what has happened. Exception to the report by the respondent has also been placed. Learned counsel, senior counsel for the appellant prays for accommodation
To give.
for hearing of the appeal.
Also to file exception, my lord, I need to file small exception.
You have not filed exception. If you have not filed exception, you have not filed exception.
Great, my lord. 7 days, my lord. I will do.
No, sir.
2 days, I will do that.
You should. It was served to you in advance. You should have.
I understand, my lord. It's our fault.
It's your fault. You suffer. Prays for accommodation of hearing the appeal. Mr. Ali for respondent presses for hearing of the interlocutory application being CA Can 2 of 2024, wherein he has prayed for stay of proceedings number so and so under section so and so with regard to the the eviction of his client from the land sites, eviction of the client and removal of the 6 way bridges from NSD dock premises. NSD dock premises, right? NSD dock premises. Mr. Ali contends.
Lord, one factual correction possibly is required. 4 in NSD and 1 is in KD.
KD.
Total 5.
In 5 way bridges bracketed, 4 at NSD and 1 at KD dock premises. Good stuff. Mr. Ali contends the writ petition had been filed the writ petition had been filed inter alia, challenging the decision inter alia with a direction upon the appellant authorities to register a lease for 30 years for the 5 way bridges in question. Full stop. Initiation of the eviction proceedings under the PP Act, hereinafter referred to as the Act of 2000. Initiation of proceedings under the Act of 71 frustrates the scope of the writ petition. Full stop. He also contends, frustrates the scope of the writ petition. Full stop. He also contends the appellants had given an undertaking that the writ petition had also given an in the writ petition, in the writ petition, issuance of a tender process had also been challenged. Issuance of a tender at Kolkata dock, right? The tender was at Kolkata dock or at NSD also? Both. Tender process had also been challenged. He contends in this backdrop, the appellant authorities had given an undertaking that the tender process shall not involve the land sites and way bridges for which the lease had been granted to the respondent. Relying on the undertaking, initially, no injunction was passed. During the pendency of the writ petition, work order was issued during. What prompted you to file the contempt? Work order issued, you filed contempt. During the pendency of the writ petition, work order came to be issued, and the respondent was constrained to take out an contempt application. In the contempt application, the appellate authorities were directed to maintain status quo as on 25th September 2023 in respect of the landslides sites and 5 way bridges in question. The appeal,
record the submission. In the context of the submission, their submission.
Yes, way bridges in question. This order was carried in appeal. This order has been assailed in the present appeal. During its pendency, initiation of eviction proceeding during its pendency. Now, though the status quo has been stayed in the meantime, has been stayed, initiation of eviction proceeding under the Act of 71 frustrates the appeal as well as the writ proceeding. Accordingly, he prays that the proceedings be stayed pending hearing of the appeal. In response, Mr. Obrojit Mitra contends that the undertaking contends that the undertaking has to be read in its proper in the contextual matrix of the case. Stop. It is recorded by the while in the order while recording the undertaking, his submissions have been recorded that his client reserves that his client is entitled to take necessary action for removal in due process of law has also been recorded. He also drew our attention to the status quo order, which records that the order is to the extent of the issues and subject matter involved in the interlocutory application being can 1 of 23 insofar as the subject tender process is concerned. Full stop. In rebuttal, Mr. Ali submits that Mr. Mitro had submits that the undertaking was given in the perspective is the undertaking has to be read in light of the submissions, in the light of the appellant's submission, that the interest of the client of the respondent shall not be impaired. Full stop. Present appeal has been the appeal is directed against the order of status quo passed by the learned single judge. The order of status quo passed by the learned single judge. While entertaining the appeal, the bench presided by the Honorable the Chief Justice has suspended the order of has suspended the impugned order. Full stop. From that point of view, initiation of the proceedings of Act 1 of initiations of proceeding in Act in the under the Act of 1971 against the respondents cannot be faulted. Full stop. Cannot be faulted. However, Mr. Ali contends the continuation of the proceedings, the continuation of the collateral proceeding for eviction would be contrary to the interest of his client and therefore frustrate the and therefore would render the now would be if continued would lead to a foregone conclusion in the appeal, which would be rendered nugator. Full stop. Would be rendered nugator. From the material and interlocutory application, it is right that an interlocutory application, it is right, reliefs in an interlocutory application are in aid, may be passed in aid of the final relief in the list. Full stop. It cannot, the scope of is to equivalent, it is tried. Maybe past now, are in aid of the final relief. Scope and ambit of the interlocutory application cannot transcend the main list. Full stop. Respondents had instituted the writ petition inter alia on twin premises, namely, one, a writ of mandamus, namely Roman 1, writ of mandamus upon the appellant respondents to issue a lease for 30 years, and 2, writ and or direction in the nature a writ in the nature of a 2, prohibitory writ restraining the appellant authorities from proceeding with a tender in the KPD. And
There is a correction. The tender was not subject matter of the original lead that was brought into by way of a can, and that can was moved when, my lord, the first undertaking was recorded.
the injunction was the writ petition also has a prayer. That is what is pleaded in the can. See clause E, page 6, prairie. Was floated primarily on the ground, twin premises, primarily on the premise that on the premise that on the premise had instituted the writ petition, praying for a writ of mandamus for issuance of a lease for 30 years in respect of the land sites and 5 way bridges. An interlocutory prayer was made to restrain the appellate authorities from issuing a new tender at the NSD and Kolkata dock, where the 5 way bridges were situated. While considering the interlocutory application with regard to the prayer for injunction on the issuance of the tender process, the undertaking came to be passed. The undertaking came to be passed, which reads as follows. Set out page 27. Full stop. When work order came to be alleging that the undertaking was breached by issuance of work order in question, issuance of work order in the tender, contempt petition was instituted, and in the contempt petition and in the contempt proceeding, the status quo order was passed in the as follows. Set out 35, page 35. Contextual appreciation of the order of status quo and the clear reference to issues and subject matter in the interlocutory application makes it patently clear that the order of status quo operates order of status quo as well the undertaking as well as the order of status quo operated with regard to undertaking with page 27, with regard to non-involvement of the land sites and 5 way bridges. Non-involvement of the land sites and 5 way bridges. Undertaking and the order of status quo operates uh, 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 undertaking operated বলেছি তো ওই জায়গাটা কাটতে হবে undertaking always as the status quo relates to the tender process only to the extent that the same shall not interfere with the land sites and the 5 way bridges for which lease was issued to the respondent writ petitioner. It has got nothing to do with the petitioner's claims that he is entitled to a lease of 30 years when the unequivocal terms of the lease agreement shows that it was for 10 years. Full stop. This to ascertain whether there was a breach. Now, Mr. Obrojit Mitro, appellants in the appeal, appellants in the appeal have made out a prima facie case. Now, appellants have made out a prima facie case that the tender process did not involve the landslide and 5 way bridges in question. This being disputed by the respondents, a special officer was appointed and he has submitted a report whose adjudication shall be made in the appeal. Adjudication of these issues have no relevance to the proceeding instituted under Act of 71. Act of 71, proceedings instituted under Act of 71 for eviction of the appellant, respondents from the land sites and 5 way bridges due to a flux of the lease period, that is 10 years. Due to a flux of the lease period, that is 10 years. Scope and ambit of the appeal, by taking out the interlocutory application, respondents have made an abortive effort to enlarge the scope and ambit of the appeal, which is impermissible in law. For these reasons, we are not in we dismiss the application for application being can so and so 2 of 2020.
I'm grateful. Much of it.
Lord, a correction in my spelling of my name, Lord, is to be carried out. The Y is in surplusage.
We'll do it. What is in surplusage?
Y.
Remuneration.
Why is in surplus?
No.
Sorry, Mr. Ali.
No, Lord.
Remuneration.
Then down it.
If I have overacted.
No, sir. Mr. Ali, you are someone whom I personally hold in high esteem.
আমি বলে দিচ্ছি
And I would always expect that I will continue to hold you in that esteem till the end of my life.
Similarly, I expressed that my colleagues.
It does not matter, Mr. Ali. Let us say this.
আমি বলছি
Today, what is the composition of the bar? 10,000 plus. Next matter.
Grateful, my lord. Much obliged.
5 minutes.
Process that is
Yeah, we will correct the order. First line, name of Mr. So-and-so be corrected in order dated.
I'm grateful. Deeply.
As so-and-so in place of so-and-so. হ্যাঁ, এটা দিয়ে তারপরে ওটা হবে। ওনার নামটা earlier order এ corrected হবে where he is appointed as the special. The remuneration you have not paid.
I personally inquired. I am
You
personally.
don't know Payush Chaturvedi.
I know, but
Huh?
I know, but it not paid. It's not known to me. Well, today itself. Today itself.
Why he has to make these submissions? It's not
Understood.
right.
It's
Yes. Next matter.
My lord, item 32. My lord, item 32, it is a contempt application in respect of the Arnish Kumar judgment, my lord.
Correct. You have filed your affidavit.
I am filing my report. But coordinate by granted in protection.
All right. Report is placed on record. We'll keep it 2 weeks hence. Adjourn 2 weeks. Other matters we are coming back after 5.
And I appear for WBSC
The
D3
50% has been deposited, my lord.
Petitioner has deposited 50%
of the final
bill,
assessment, my lord.
of the final bill for unmetered consumption to the tune of so and so in view of the aforesaid fact and the nature of offense, we are inclined to grant and
Fine.
next.
Grateful, man.
I'm for the petitioner, your lordship.
And I am for the petitioner. An allegation of 195A. The other day, your lordship asked me to add the CBI. I have served the CBI. The fallacy of this case.
Principal case is investigated by you.
Lordship, I have to check it up. Which case was investigated? One case has been transferred. I have to take instruction.
Principal case is transferred.
But the case which has been registered on the basis of a writ has been taken over by CBI.
In connection with that case, witnesses have been alleged to be threatened by the petitioners in this case.
There is little bit confusion, Marat. Even that's why I was
So not
asking my
today,
friend.
not today.
But initially there was a writ.
Not today.
Marat.
Get clarity. Adjourn for the day. Next. Hundred and five is
petitioner, my lord. I'm no, my lord, working with him is like this is a case of road accident, my lord. Even the petitioner sustained injuries, was taken to the hospital, 3 stitches given, my lord.
yes.
There was a long-standing dispute between the petitioner and the husband of the victim who died. My lord, he was an employee of the husband. And my lord, there was some intention, there was some
Let us
intention.
This is the
He didn't have a driving license also.
So why did you jump into his car?
my
motorcycle.
bike was unregistered, my lord. There was no number plate in the bike. And my lord, the version of the eyewitnesses at page 10 and 12, the lordship will see. The page 10 and 12 is the
Well, any intention? Did he have any intention to assault?
He was an employee, my lord, and there was a financial dispute.
What?
From the witness statement of the witnesses, eyewitnesses, well, it is an accident. Now,
Not accident.
but can you see page 10 and 11 is daughter in daughter. And so far as page 10 and 12 are concerned, are the witness of the eyewitnesses. Statement of the eyewitnesses.
The thing is that if he had a
Well, we have gathered a CCTV footage. Now, my lord, we will be sending that to FSL. My lord.
That is not material. CCTV footage will only say that you will see
whether it is deliberate or not.
You will not understand. Whether it's deliberate or not prompts through motive. Did he have motive to commit the crime?
Lord, 7 except the statement of the complainant, we do not have anything else.
Nothing is there.
And my
Now
lord,
the investigation is going on.
Go on.
my lord, one thing, even he sustained injuries, 3 stitches were given.
That is all.
That is accident. That is all.
Appellant petitioner contends that he suffered that there was a road traffic accident and he also sustained injuries. He prays for anticipatory bail. Learned lawyer for the state opposes the prayer. Learned lawyer for the de facto complainant submits. Petitioner had monetary dispute with the son of the
With the husband now.
with the husband of the deceased. We have considered the materials on record. Statements of witnesses show petitioner while driving a motorcycle hit the deceased, hit the victim. She died subsequently. Stop. It is unclear whether petitioner had also suffered injuries in the course of the incident. Although in the FIR it is alleged that there was monetary dispute between the parties, no other statement corroborates this version. In view of the aforesaid facts, we are inclined to grant anticipatory bail, 10,000.
I'm grateful.
Next.
41. 41, and for the petitioner. Yesterday, your lordship, my lord, had a look at this file, my lord. 406, 409, 408, 465, 467. My lord, the complainant is, my lord, director of a company called Lindcow Mobiles India. My lord, which is, my lord, the company that.
What is the complicity?
My lord, he was the assistant area sales
Money
manager.
flowing into his account.
No, money was all taken by the manager, then distributed.
Distributed, something went to him.
No, that has not
Didn't
come in
go.
the
No.
2022 case. He was absconding for this case.
Petitioner contends that he is one of the employees.
My lord, may I just point out 2 more things, my lord. One, the co-accused person had approached this honorable court. White CRM A2370, that was turned down by this honorable
That
court.
is exactly why we asked you whether there is monetary transaction.
Yes, no, that's not there in
So
this
it's a
case.
distinguishable.
And my lord, there are 5 other cases pending against this petitioner.
5 cases.
5 cases.
My lord,
One in Hay Street. This is the report, my lord.
my lord, I am on anticipatory bill in these cases. All, my lord, relate to, my lord, the same audit which was being conducted, my lord, in various, my lord, service centers of Oppo brand of mobiles, my lord.
But how you get involved in
My
all
lord,
the
they have, my lord, the same complainant, my lord, has lodged these FIRs, my lord.
but in those cases, you were not in charge of those offices.
No, my lord.
So
My lord, so far as, my lord, this case is concerned,
what
my
is the
lord,
total number of handsets
My lord,
misappropriated?
they claim around in the audit report at page 38, my lord.
30 to 35 lakhs.
They claim around
500.
30 to 35 lakhs, my lord. That is, my lord, the allegation as my lord is coming out from the chart sheet. Chart sheet has been filed in this case.
What they did was they uploaded in the system of the company that 500 mobiles had been returned to them because they could not be repaired. They were not in repairable condition. The fact is that when the audit was conducted and they were asked to produce all those handsets which they claimed that they were returned, they could not show those handsets because the handsets were already repaired and given to the customers. The customers had already paid the money. They generated forged bills, invoices, and gave it to them.
My lord, my learned
And
friend,
in that regard, the entire defalcation took place.
But my learned friend's case in the charge sheet is that the entire thing was masterminded by a person called Shubhopriyo Haldar, who was the area service manager, along with Joyashree. Shubhopriyo was arrested, granted bail. Joyashree was refused anticipatory bail by the coordinate division bench on the ground that she had received money. So far as I am
Shubhopriyo
concerned,
is the area service manager.
I am the area. I am
was in
the.
custody for
Yes,
constable.
Shubhopriyo was the area service manager.
And you are?
I am the
He's the
assistant
assistant.
service manager, and I was earlier. I was, my lord, a service manager. I was promoted, my lord, subsequent.
All right. Petitioner is the assistant, was the assistant service manager and posted at Chandanagar,
Lords,
right?
lordships.
Chandanagar in Oppo India Service customer Oppo India Service Center.
Lordships.
Full stop. Subsequently, he was posted as he was promoted. In course of audit, 500 during audit, there was a mismatch of 500 devices, 500 handsets, which value of which is alleged to have been misappropriated. Petitioner was falsely implicated in these cases. He has been granted pre-arrest bail. Investigation is complete. He has been granted pre-arrest bail in other cases. Learned lawyer for state submit prayer for anticipatory bail of one Joyashree Das was turned down by a coordinate bench of this court. We have considered the materials on record. It is alleged 500 handsets. It is alleged that 500 handsets. It is alleged that the value of 500 handset. It is alleged that employees attached to the Oppo India Service Station at Center had made false entries and misappropriated the value of 500 handsets. Full stop. Investigation reveals that the crime was committed by the area sales manager in aid with Joyashree Das. Full stop. Money trail shows the misappropriated money. Money trail shows misappropriated money being credited to Joyashree's account. No such material is placed before us with regard to the petitioner. Investigation is complete. In other cases, he has been granted anticipatory bail. Accordingly, we are inclined to grant similar relief to the petitioner.
I'm deeply.
My lord, item number 42, I am for the petitioner. My lord, allegation under section 498A, 323, 320, 325 of the Indian Penal Code, read with section 4 of the Muslim Rights Act, my lord. My lord, no prior complaint, my lord. My lord, 22
We have
years of
considered the materials on record.
and no medical.
Petitioner is the husband of the victim lady. Allegations of torture are general and omnibus. No medical report with regard to physical assault is placed before us. Accordingly, we are inclined to grant anticipatory bail subject to condition. Meet investigating officer once in a week under further orders. Next.
85 of the BNS, that is 498A, husband, 2.5 year,
We have considered any injury report.
Injury report is there, abdominal pain and chest pain.
Then
there is an allegation of
My lord, section 126, 115 and 109 by 3 by 5, fight between two neighbors and injury.
Section 8 of the POSCO Act would also added, your lordship, suppressing the fact after that they had paid
I am for the petitioner. Petitioners are the mother-in-law and cousin sister-in-law of the victim lady. Husband was arrested and later on released on bail. I have annexed the order at page 9. After 3 years of marriage, the victim lady due
Number
to
1 is the mother-in-law and 2 is the Didi Shashuri, grandmother-in-law. That is the 164 statement.
no lordship. Petitioner number 2 is the cousin sister-in-law of the victim housewife.
Medical papers.
Yes, my lord, page 42, 43. My lord, she was admitted in the hospital from time to time, my lord. She underwent one operation also. So that is why there is a delay in lodging the FIR already, my lord.
Six 424 to
Page 42 is the endoscopy report which says corrosive gastric injury.
that we have seen.
Then 43, my lord, discharge certificate.
Where she was admitted first.
My lord, she was admitted in the Bahrampur hospital, then in a private hospital, then again in another hospital, government hospital, Domcall hospital, my lord, at Domcall. Page 45, my lord, that is a discharge certificate, where it has been stated that she underwent one operation, feeding jejustomy.
First you applied and then not pressed it again.
Yes, earlier it was not
Lordship,
pressed.
that is the petition of aunt-in-law. There was some mistake in the cause title, Lordship.
Reason has been stated that since charge sheet has not been submitted, it was not pressed. Now charge sheet has been submitted.
Lordship, husband has been granted bail.
After more than 30
Maybe
days.
she consumed acid herself. But the torture was there.
But Lordship, husband has been,
was there, my lord.
husband was apprehended and later.
What is the age of the grandmother-in-law?
As per their petition, my
Lordship,
lord,
it's 37.
Reshma baby.
Reshma is a, my lord, grandmother-in-law.
She is 37 years.
That has been stated by, but in the 164, my lord, has
Lordship,
seen, my lord,
petitioner number
Dida
2,
Shashuri.
37 years. She is the cousin sister-in-law of the.
But in the 164, but every neighbor statement, it has been stated Dida Shashuri, my lord. So grandmother-in-law. But
To find out, tell us what is the relationship.
grandmother-in-law, my lord, everywhere it has been. I don't know
How
where
can
from.
that be 37 years?
But that has been
Let us
stated
see
by
the
the
Aadhaar
petitioner.
card. Aadhaar card of Reshma. Produce the Aadhaar card of Reshma. In the medical report, it is said ingestion of acid.
Yes.
She herself took it.
But my lord, in the 164, she has stated that since the husband was present, he was.
That is the first hospital.
Yes.
But in the private hospital, it is acid ingestion again. Was she with the husband even then?
Husband was there also.
Huh? Now, if the husband tried to pour acid, will he go and take care of the wife and arrange for her medical treatment in 3 hospitals?
That is there.
We want to know what is the correct age of Reshma baby.
Lordship, right now I don't have the Aadhaar card.
Correct, adjourned.
Grateful, Lordship.
Adjourned. Next. Not today. Not.
I am for the petitioner, Lordship. Okay. After 8 years of the marriage, Lordship, the present if I lost, Lordship, presently, Lordship, both are decided on the same age, Lordship, and charge is submitted, Lordship.
What are you saying?
Now the petitioner and the de facto complainant are residing as a
Parties have amicably resolved their matrimonial dispute. It is contended, but they are residing together as husband and wife. In view of the aforesaid development, we are inclined to grant and switch repeal. We are of the opinion committing petitioner to custody would not serve any worthwhile purpose. Accordingly, we are inclined to grant and switch.
Great.
Next.
My lord, I am for the petitioner. I am for the petitioner, my lord. My lord, case under section 117, 118, and 109 of the Bharatiya Nyaya Sanhita. It is 326, 307, my lord. My lord, what happened, my lord? There was a scuffle on that day. The complainant and his people mercilessly assaulted the petitioner, my lord. He got heavily injured.
Someone walking on the street, you go and hit him with a pamphlet. We have considered the materials on record, including the injury report. Injury report does not disclose grievous injury. Accordingly, we are inclined to grant answer.
I'm grateful, my lord. I'm grateful.
Next.
My lord, I am for the petitioner.
Pawan Gupta.
For offences under section 406, 420, it is alleged that amount of rupees 1,50,000 has been defalcated by the postal agent. But my lord, may kindly see the limited authorization given to this postal agent. This account had no facility to withdraw check amount through the check. So, my lord, until and unless a person is having access to the portal, that amount cannot be withdrawn. Your lordship, kindly see the limited authority granted to this particular person, my lord. And my lord, I have complied notices under section 179 twice served upon me. My lord, but I have named in FIR, that is why I prayed for anticipatory and that was rejected, my lord. So, my lord, I am compelled to file anticipatory bail application.
Then 17 and 118
Kindly see the authorization given to me. I have only permitted to deal with the account from customer to the postal office and to carry money and to deposit money and to give receipt. And my lord, I have just marked the portions. I have no access to the portal. And in FIR, my lord, is specifically admitted that account has no check facility. So my lord, until unless the person appears physically or any person has access to the portal, amount cannot be withdrawn.
117 and 118 logically money was withdrawn
Withdrawn by whom?
by this.
How do you know?
That is, that is specific. There is no.
Huh?
No specific.
So if no specific, he will go to custody before you find out material.
Well, he was given the chance to withdraw the money.
Who was given the charge to withdraw?
Not can't be. My lord,
He
kindly
says
see.
he didn't
In
have the
FIR, it is written.
He signed the check.
Who signed the check?
The FIR maker say the account has no check facility.
Where is the check facility?
My lord.
That, so for that part is concerned, when the investigation is going on.
So going on why custody? Why custody? Are we dealing with mindless agencies depriving liberty? Tell us why custody? What is the suspicion around him or his activity which will have you the right to take him in custody? What is there?
My lord, there's nothing. As of now, my lord, investigation has not, my lord, I have spoken to the investigating officer. He has not found any material against him as of now.
Twice I have complied 179 notice.
Petitioner submits that the account of the de facto complainant had the account of the de facto complainant could only be electronically operated. There is no scope of withdrawal of cash through checks or in physical mode. His role in the bank, he is a postal agent and does not have access to the online portal of the post office. He cooperated with investigation and prays for anticipatory. Learned lawyer for the state produces the case diary. We have considered the materials on record. Petitioner is a postal agent and it is contended that he had no access to the online portal through which the account could be operated electronically. Allegation that he forged physical documents to withdraw cash appears to be improbable. He has cooperated with investigation. Under such circumstances, we are inclined to grant anticipatory bail subject to condition meet investigating officer once in a week.
My lord, till the charge sheet is submitted at least.
Deeply obliged to Lord.
Grateful, my lord. Grateful, my lord.
Beloved, I am for the petitioner. Beloved, over the property dispute, beloved, there is a case and counter case. Beloved, we had also filed a case, and beloved, the against us this
Suppression marks on the neck of the
We
complainant.
have considered the materials on record. It is submitted. There was a free fight. Case and full stop case and counter case were registered. He prays for anticipatory bail. Learned lawyer for the state opposes the
24-25.
page opposes the prayer. We have considered the materials on record.
The complainant, my lord, on page 24 and the complainant's wife on page 25.
We have
The-
considered the materials on record, allegation, including the injury report. Though one of the injuries are on a vital part of the body, that is neck, comma, the nature of injuries are not grievous. Not grievous. Possibility of the injuries being caused in the course of a free fight and cannot be ruled out. Under such circumstances, we are inclined to grant anticipatory. Next.
service completed. Beloved, I am for the
My lord, item number 53, my lord, there is another case, my lord, in connection with the same police station case, my lord, 4179, my lord, that is fixed on Monday, my lord. So matters may be taken together because, my lord, in that case, my lord, I have taken specific plea that the contraband which has been recovered, my lord, is having the Debabrata Das is having valid drug license and my lord, permissions from the competent authority, my lord.
50,250 bottles.
So, my lord, in that case, my lord, I have taken that plea, my lord, and on petition has also been filed before the learned trial court, my lord.
List along which ones? List along with CRM
My lord,
A
4179.
417.
Grateful.
But can it be on Tuesday, my lord?
Because
that is on Monday.
Monday, my
Ask for adjournment on Monday.
grateful, my lord.
Next.
My lord, I am for the petitioner, my lord. My lord, allegation under section 325, 326, 307, 34 of the Indian Penal Code, lordship. There was a dispute taking the measurement of the property, land property, lordship.
Injury report, my lord. My lord, rural hospital, my lord, but they referred to Murshidabad, that was not even received.
He is still in hospital.
Yes, 6 persons injured, my lord.
6 persons injured. So get huh?
No, my lord, they are not, right now they are not in, my lord.
Right now there. One is maybe grievous.
My lord.
Please see whether
It is simple, one is my lord, a simple injury, one is my lord, maybe grievous.
no, that maybe grievous says that it is doubting fracture.
They refer to my lord to Murshidabad district hospital, my lord.
To get can you get the medical papers from Murshidabad?
No, my lord, not yet, my lord.
There are two, page 30 and page 26. Right. One is Halim Ali, another is Anamul Haq. Both are maybe grievous. The injuries may have caused fractures. So please get a clarification. We have considered the injury report. Some of the victims were referred to Murshidabad Hospital. Medical report from Murshidabad Hospital be produced. Matter is adjourned 1 week. Petitioner shall not be arrested 2 weeks in connection with this case for a period of 2 weeks or until further orders, whichever is urgent.
Grateful, lord.
Next.
My lord, 55, my lord, I am for the petitioner, my lord.
Yes.
409 of the Indian Penal Code. My lord, the amount which has been described as misappropriated, that has already been deposited by me. Articles of charge has been placed. Articles of charge has been placed, and I also filed my lord written objection against them. My lord, kindly see page number 16. It is admitted position that I have already deposited the said amount. Kindly see page number 16. It is there, articles of charge.
Has since
and charge sheet is submitted, my lord.
Where? Where have you deposited?
Hey, my lord, page number 16. My lord, kindly see page number 16. Column, on detection, apostate misuse of ID by Mr. Tormadas, you had compensated the misappropriated money from your own fund.
Petitioner has deposited the misappropriated sum as would appear from the articles of charge served upon him. Though petitioner was a bank officer and it is alleged that he had misappropriated public funds, in light of the fact that he had refunded the amount, we are of the opinion, we are of the opinion, committing the petitioner to custody at this stage, committing the petitioner to custody is not necessary and he may be granted and allowed.
I love Lester, my lord.
Yes, next matter.
My next matter also, my lord, I am for the petitioner, my lord. My lord, allegation is, my lord, I was moving with a forced epic card for obtaining Shastrosati card. Nothing more, nothing less, my lord. I was moving with forced epic card for obtaining Shastrosati card. My lord, thereafter nothing has been made. I could not collect
the card to. It is alleged petitioner had used.
It was not used. It was not used, my lord. It was not used. It was not used. My lord, kindly see, my lord.
Then, that's what I'm saying. petitioner had used a forged voters identity card to obtain health benefits from the government. However, no such benefit had been extended, and the alleged forged document is in the custody of the investigating agency. Under such circumstances, we are of the opinion custodial interrogation for progress of investigation is not necessary, and petitioner may be granted answer.
High level Leicester, madam. High level Leicester.
Yes.
Madam, I've got the certified copy. Now, madam, there was never a prayer for shown arrest at the first point of time. The order which your lordship was seen.
Production warrant was issued.
Only.
That is enough.
Madam, no, the prayer was only for production warrant.
So you want to argue this, right?
Yes, madam.
All right, argue.
Well, it seems your lordship is not receptive to my argument.
Supreme Court is not receptive to your argument, not us.
Why, my lord?
Because the Supreme Court says that if a production warrant has been issued,
could I see the judgment? I am not aware of it, but
judgment that you placed yesterday.
No, that I've got it, my lord.
Yes.
See the conclusion part, my lord.
Tell us.
Dhanraj. See, sir, my lord.
Yes.
Come to 60, my lord. Paragraph 61 onwards.
Please place it.
No, my lord. My lord, I wouldn't know because if the production warrant was enough, then why should a prayer be made by CBI to show me arrested on the next day?
We don't.
My lord, please seize the order. But please seize the prayer.
Let us see the judgment first.
But it sees the production. Their prayer, my lord.
Let us see the judgment first. What does the law say? Please help us to understand the law. Conclusions.
My lord, one thing is sure, my lord, I think, my lord, if your lordship comes to page paragraph 54 first.
Yes.
Paragraph 54. Even paper arrest, my lord, will not allow me to be. I can have a right to apply for anticipatory bail.
Right. Till he is arrested by the police on the near formal arrest, not extinguishing. Yes. All right.
Judgment it doesn't matter. Well, well, the conclusion is paragraph 61. Sorry, 60 থেকে আরম্ভ 60 থেকে আরম্ভ Paragraph 60. जस्टिस कांत के बोलते की मार्केट Well, the first prayer is of 25th, Malad. Please see the prayer of the IO, Malad. On 25th, the prayer of the IO, Malad, I've annexed it. Malad, page 9, Malad, page 9. Page 9, Malad. Humble petition filed by CBI in issuance of production warrant against Sujay Kishore Bhadra. That's 25th. Then, Malad, on 26th, the IO makes a prayer for shown arrest.
Yes, Mr. A. What do you mean by this prayer of shown arrest on 26th?
Well, we had already shown him arrest, Milord, as far as
We are
order is
asking
concerned.
you about your prayer of 26th.
Milord, I apologize. The first prayer, my lord, is the first application which was made on 25th. My lord is on. My lord, here the prayer portion, which I see, my lord, it is saying that production warrant.
Production warrant. Then what shown arrest?
My lord, in my respectful submission, my lord.
A shown arrest precedes production. A shown arrest precedes
My lord,
production
I
warrant.
bow down. I bow down.
So if you bow down, explain 26.
My lord, what has happened is it is very much reflected from the order itself. The first order.
Mr. Trivedi, your officer is praying for shown arrest. Why? Why is he asking for shown arrest on 26th when an order of production warrant already on 25th?
But then
that means he's a sub-inspector of local police station. This is the confidence rested in the specialized agency by the High Court in a multi-crore teacher scam case. Who doesn't know the distinction between shown arrest, production warrant? Or is it some other sources which are influencing the wisdom of the officer?
No, my lord.
No, there are two options. Either ignorance, which betrays constitutional trust vested in the agency, or extrajudicial influence, which prompts the officer to forget what is the law. Tell us which one is there.
My lord, neither here nor there. My lord,
Then which, where?
Inadvertence, my lord.
What inadvertence?
My lord,
This is inadvertence.
My lord,
this is inadvertence.
My lord, I
Then
cannot
who
say
is the
it's one
public prosecutor who gave him opinion to make this prayer?
My lord,
Who is the public prosecutor who gave the opinion to Wasim Akram Khan?
My lord, what
Wasim Akram Khan must file an affidavit explaining why he asks for shown arrest after a production warrant is issued.
My lord, once again, may I?
Is he trying to assist the accused person? Hmm?
My lord, it was.
Or your agency is doing a eyewash?
No, my lord, that is not that, my lord. If my lord so deems fit and proper,
Leave
we
the
have got-
accused if you don't want to arrest. Come clean breasted. Don't leave things to defect so that the accused can escape between the fingers of law. That's not the
But
duty of a fair, decent agency.
I apologize, my lord, but this is a. I would not say. I will not go to the extent of saying it is a bona fide mistake. It is an inadvertent mistake which should not have been made, my lord. Because
So
with
take
all
steps
good
against this
intentions-
officer.
My lord,
Remove this officer.
my lord.
Remove this officer from the investigating agency. Let us see what you do as a employer.
My lord, he is a very good officer. My lord.
No, if he is a very good officer, why the reflection is
My lord,
not there?
if my lord will kindly see what
Why he
investigation
pays
has
for
been-
you explain, Mr. Deputy Solicitor General.
My lord.
We may be wrong in our understanding. Today, there is an interpretation of law by the Supreme Court. There is some degree of, we would say, arguments possible with regard to the ratio. What is the difference between a production warrant and a formal arrest? What do you mean by a formal arrest? What do you mean by you enlighten us? What the paragraph 54 means? What is the formal arrest? Does it mean the physical communication? Then the line says that formal arrest precedes production warrant. Then in the interregnum, there can be
application for
anticipatory bail. But if the production warrant is already there, then how can a prayer for formal arrest be made? It is already subsumed in the prayer of production warrant. File your response to this.
It should have been worded in a different manner.
Would have been worded. What would be the wording? Tell us.
My lord, in my respectful submission,
What would be the wording?
What has fallen from my lord that
what should be the wording? Tell us.
My lord,
you either take steps against an officer who makes this application, or we pass our opinion about the quality of investigation in this case.
My lord, will not be that harsh.
What can we do? We are asking you to be taking disciplinary steps. You are not taking. We have seen wonderful exercises of, we would say, delay in progress of proceedings. In one of these scam cases of which we had seen of bail application, we found how the state chief secretary is dragging his feet in not permitting a decision being taken about grant of sanction, and thereby in some way, inadvertently, as you will say, or otherwise assisting accused to get bail. You have no answer why a production warrant order prayed aloud gets muddled by a prayer on the next day for shown arrest. You file your affidavit. Let the officer file an affidavit. Why this exercise? What is this exercise all about? Affidavit, petitioner.
In the interim, this should not become infructuous.
What infructuous?
The anticipated bail application.
You will have a bail application.
Well, then the whole thing
You will have a bail application.
Well, an interim press, small, only.
You want us, we will make it clear that this is an absolutely uncalled for application for showing him arrested. The formal arrest is precedes.
No, that's true.
Desire to arrest is the formal arrest. And the communication.
Till such time they file the affidavit, Malad. Only to that extent, Malad.
No way. This is either, as we made it very clear, we accept the Deputy Solicitor General submission that the formal arrest is inadvertent. That is the, I would say, least and the most charitable stance that we can take about this
proceedings.
What we would say, putting the hand of the clock back. Mr. Mukherjee, you are an experienced lawyer.
Don't embarrass me by saying all
An
this.
experienced lawyer. It's something like an
Don't
accused.
embarrass me. Don't embarrass.
It's something like an accused praying for discharge after charge is framed. All right. What will the judge do?
Well, it's true. Well, it's true. Well, can't I take advantage? Well, can I take all on records? I have come before your lordship.
The assistance of the Deputy Solicitor General.
Well, let the affidavit be
Sir,
filed.
please tell us, how do we read your prayer of 26 when the judge has already issued a production warrant? What is a production warrant? The man is not before me. You are wanting
In another case.
So, in other words, the prayer for shown arrest is inferred in the prayer for
production.
Production or the formal arrest is informally communicated. Now, there need not be a subsequent communication.
Malad, as I told your lordship yesterday, 392 has another forum. So, Malad, the production warrant, because I have not been made an accused as yet.
Mr. Mukherjee, the limited area what we may ask you to
answer
is, does the ratio in
this thing, Malad, Dhanraj Aswani,
permit an anticipatory bail in the interact between the issuance
of the
and execution of production warrant?
Malad, where is the bar here?
We are asking you.
No, I'm sorry. Well, I
from that and say, where is the bar? Apply your mind and address us.
Okay, I'll do that.
Because this paragraph doesn't
54.
say. It clearly says.
Malad, it is, I'll be honest to your lordship, it can be going this side, that can go to that side. But Malad, the conclusion is 60. Malad, your lordship sees conclusion 60 and 61.
Tell us, where is the conclusion unequivocally saying that a production warrant not executed?
No, PTW, Malad, has not been said. That has not been said in so many terms, Malad. But Malad, your lordship is saying that but if I've got your lordship correct, the prayer for shown arrest
police remand has not been passed. It is an offense. While being in custody in relation to will only be available to till he is arrested by the police officer on the strength of a production warrant obtained by him in the court.
Yes, that is what.
This line helps him. So if just production warrant is issued and it has not been communicated to the accused, we must clarify mere formal arrest on paper will not execute the right of the accused to apply for ransom. We say so because a formal arrest would not result in the submission of the accused, who is in custody, to the custody of the police officer effecting a formal arrest. Yes. Mr.
A little ray of hope.
Mr. Mukherjee, with respect and with folded hands, sir, please apply yourself and make an argument forensically. There is no ray of hope.
No, man, I'll tell you lordship what, man. If a lordship, if I'm going by 54.
Please read 54. Let us read 54. Let us understand 54.
Man, I've read it, but I've read
it aloud. You have not read it.
No, man, for a change, I've read it.
No, if for a change you have read it, please
share
your reading with us.
Yes, Malad. The option of applying for anticipatory bail in relation to an offence while being in custody in relation to a different offence will only be available to the accused till he is arrested by the police officer on the strength of the PT warrant obtained by him from the court concerned. We must clarify that mere formal arrest on paper arrest would not extinguish the right of the accused to apply for anticipatory bail. Well, here I join issue, my lord. Here is where I join issue, my lord. My right under 438 does not go away. We say so because a formal arrest would not result in the submission of the accused, who is already in custody, to the custody of the police officer, effecting a formal arrest. The police officer, on the strength of the same, procures a PT warrant from the jurisdictional magistrate. The accused would have no other choice but to submit to that compulsion, and the accused right to apply for anticipatory bail
Now you see,
would get extinguished. Well, let them give an affidavit, man. Let them give why they made this to prayer. And even the learned court on 28th also, my lord, said, unless the production is there, there's no question of a arrest.
to apply for custody relations. Contrary to the first line.
My lord, as your lordship, my lord, yesterday I read out, my lord, from 302 subsection 2. My lord, there are two parts to it. Because this is all under 267, new 302.
Do you understand?
দে বইটাতে এটা নতুন এটা But while he was in custody in connection with the ECIR case, my lord, he was summoned as a witness. So conversion from a witness to an accused is what is happening. So, my lord, if your lordship sees A, that the person confined
Right.
prisoner transfer warrant. Production warrant, petition. Petitioner transfer warrant.
In the facts of that case, there was no production warrant.
No PTW.
He was arrested in the penal code predicate offences. Then the ECR was registered.
Then he was
placed for anticipatory bail, relying on Saini.
Yes.
The judges overruled Saini and said no. He can always be taken into custody. He can always seek anticipatory.
Yes, that's the facts of the matter.
Now here what has happened is you have approached us at a time when the production warrant was issued, rightly wrongly, and was communicated to you, served upon you. So the issuance of the and now in that factual setting,
Yes.
setting,
Yes, my lord.
if you see the last line of paragraph 54, that
From the jurisdiction, magistrate accused would have no other choice but to submit to that compulsion.
yes,
And the right of the accused to apply for anticipated is extinguished.
right.
Yes. But the fact remains, my lord, this was never served upon me. In the sense that it is served on the officer in charge, then to
That is
bring
the
me.
sir.
No,
That
that
is the
to
sir.
get
That
to
is the sir.
no, no, true. But well, there the arrest part was not there.
The production warrant itself, so it says.
Well, according to your lordship,
if
production
after
warrant
taking a
involves
formal
shown arrest.
arrest,
That is what my lord is trying to say.
what is a formal or on paper arrest? That is shown arrest.
Yes, that is not been done.
So
I can apply for 438.
The production warrant has already been done, which infers a shown arrest.
But what the judge has said, that unless production is done, because he did not
That
take
is the
production from
judge's
virtue. So that is what I'm saying, my lord.
That is a judge's erroneous understanding that is not going to confer jurisdiction on this or an correct line to interpret the state of affairs.
No, true.
A state of affairs is a prayer for production warrant was made
on 25th.
25th, which came to be allowed.
Yes.
It was communicated and served upon the
OC,
superintendent of the
yes, yes.
correctional home, and therefore was in fact communicated to the accused, to your client.
My lord, if your lordship sees 3 and 4, my lord, if your lordship sees 3 and 4 of the CRPC.
Correct.
The new book, my lord. 3 and 4.
Yes.
So my the production was never affected.
Production
was never affected. So the arrest part remains as it is. That is why we have come under 438 before lordships.
Production was never affected.
Yes, well, because this has been given by reason of so and so. What happens? The officer in charge of the order made by or so and so under sections applies. The officer in charge shall abstain from carrying out the court's order and shall send to the court a schedule.
They must give reasons.
Yes.
They must give reasons. So ABC.
So yes, well, the last part. Well, let them give an affidavit, Malad.
Yeah, that we would.
315, man. 120.
Will come at 2 p.m. Yes, Mr. Trivedi.
Whatever falls, if my lord wants me to come at 2 p.m., we'll come.
Otherwise, we'll finish. Gives an order of evidence. Affidavit.
For affidavit, what has fallen?
So you file your affidavit.
Yes.
Petitioner contends that the that he had not been shown arrested earlier. He had not been shown arrested in the instant case, and the production warrant issued on 25/11/24 has not been acted upon. Subsequent, no order has been passed on the no order was passed on the subsequent prayer to show arrest. Subsequent prayer for showing the petitioner arrested on 26/11/2024. In view of the ratio in Dhanraj Aswani, now referring to paragraph 54 of Dhanraj Aswani, Mr. Mukherjee contends that the prayer for shown arrest, prayer for anticipatory bail is maintainable. We have Deputy Solicitor General seeks leave to file affidavit. Now, we have looked into the materials on record. On 25th, 11/2024, prayer was made.
Page 9, Page 9.
Prayer was made for issuing production warrant against the petitioner against production warrant of against the petitioner as substantial material has transpired against him in the scam
on RC6
in the scam relating to appointment to undeserving candidates in schools, aided schools, in various aided schools. The prayer came to be allowed on the same day. On the next day, the investigating officer prays that the petitioner be shown arrested, prayed for police custody.
Or both, my lord.
After
both, my lord. May we kindly shown arrested?
Prayed that the petitioner be shown arrested and remanded to police custody. Learned judge observed prayer for custody can only be passed after
production.
The accused, after the petitioner is produced. Full stop. If a prayer for production warrant of an accused to clarify the stance of the investigating agency, we call upon the investigating officer to submit affidavit to clarify the ordinarily a prayer for showing a person showing an accused arrested in a case precedes the prayer for production warrant. Full stop. Paragraph in the prayers of the investigating agency requires to be seen in light of the observations of the apex court in paragraph 54 of Dhanraj Supra. Affidavit of the investigating officer. Investigating officer is directed to submit affidavit within 1 week.
Slightly more, maybe more than 1 week.
Within 2 weeks. Matter will appear 3 weeks hence. Reply if any 1 week.
Interim.
What interim? They will not do anything. They are waiting for you. Don't worry.
I'm
Nothing
great.
will be done.
My lord, may I ask a personal question to Justice Kant with your lordship's person? Well, where do we get senior gowns in Delhi?
Observation. The prayer was for police remand. If you see it in that perspective, he has prayed for production warrant and then he has prayed for police remand. And the judges rightly said, first physically produce the accused or produce him through electronic means and then police remand. The shown arrest is more in the nature of a reference point. The question is, however, to understand the two observations in paragraph 54, the first line saying, till arrested upon production warrant being issued, he has a right. And the second line says, once formally arrested and production warrant is issued, there is no other option
but to
surrender.
Great.
Correct. So these need to be reconciled in contextual and legal interpretation.
Grateful.
Other matters will take up at 2:15.
Right. 2:15.
2:15.
Grateful.
One as matter has been assigned to your lordship's item number
Well, that time
66.
for the petitioner, well, bail matter has been assigned. Well, he has sent case ready back because not today,
but Tuesday, Malad.
Acha, Tuesday. As it is not Tuesday. Great. Well, that matter. Well, that fake lordship's orders, that fake. Oh,
Our case has been transferred
to Calcutta.
Calcutta. So I've deposited the case.
Yes. Password কি আছে?
Trustee, I have for the petition. Trustee 307, C76, 500.
We'll keep the appeal matters 1 week after 1 week. Adjourn Monday week. Next.
Well, 59 I am for the appellant, my lord.
59 there is nothing. We dispose it of.
My lord.
Appeal is directed against judgment and order dated 58 we are keeping on 9th.
9.
Because 58 will require a bit of consideration.
58 and 59.
Please no exculpatory confession.
Confession of by the appellate.
What is to what extent prosecution can rely on exculpatory confession? Please find out and place judgments on this. Because so far as Dulal is concerned, it's an exculpatory confession. Whether it can be used against the maker. So far as Nima is concerned, exculpatory confession until and corroborated, no way of relying on it. But with regard to Dulal, how much can the prosecution rely? Because even if you accept the exculpatory, you admit your presence at the place of occurrence. Then other materials that has to be checked, please. Now, Shodhamuni, let us finish it. 15 minutes.
Sixty to 60
Appellant is
60.
Appellant has assailed judgment and order dated 21/6/2019 and 24/6/2019 in sessions trial number so and so, sessions case number so and so, convicting her for commission of offence punishable under section 302 of the Indian Penal Code and sentencing her to suffer rigorous imprisonment for life and to pay a fine of 50,000 in default to suffer rigorous imprisonment 1 year more. Prosecution case against the appellant is to the effect that on 9/5/2015, the victim, Padmavati Sardar, was returning home in Lokhikantopur local train. On 10, huh? When the train entered Joynagar station, there was an altercation and Padmavati was pushed by the appellant from the train with the intention to kill her. She fell down and suffered injuries, and she was shifted to a nursing home. Full stop. Appellant was detained was caught by local people and detained. Padmavati's father, PW1, lodged complaint at police station, resulting in Baripur PS case number 32/17 dated 10/5/2017 under section 307 IPC. Unfortunately, Padmavati did not survive and section 302 came to be added. Did not survive and 302 came to be added. Charge was framed against the appellant under section 302 IPC. She pleaded guilty and claimed to be tried. In course of trial, prosecution examined 17 witnesses and exhibited a number of documents. In conclusion of trial, the trial judge, by judgment and order dated so and so, convicted and sentenced the appellant as aforesaid. PW1 is the father of the deceased.
PW1 is a constable.
No, Kumar Mondal.
PW5.
Oh, sorry. PW5 is the father of the deceased. He deposed. His daughter was thrown from the train at Joynagar platform number 1. Police personnel shifted her to Shantanu Nursing Home, Lokhikantopur. 5-6 days later, she died. Police had arrested the miscreant at the spot. Dispute arose over sitting arrangements in the train. He lodged complaint. PW1 is a constable attached to who was attached to Baruipur GRPS at the material point of time. He stated that he was on duty. He took the victim to Shantanu Nursing Home after informing Baruipur GRPS. PW1 and 2 are GRPF officers. They stated that a lady had fallen down, had been thrown from the train, and they shifted. PW3-4 3 and 4 are train passengers. PW3 stated she saw one lady being pushed from the, she was in the train at the time of, she was in the train, she saw one lady named Padmavati was pushed by another from the train. She identified the lady before magistrate during TI parade and also in court. Full stop. PW 4 corroborated PW3 and stated that Padmavati had been thrown from the train by a lady. However, she could not identify her. আচ্ছা ওই PW5 কমপ্লেন করেছে তো স্ক্রাইব বাই PW6. PW10 is the doctor who treated Padmavati at the nursing home. He found scalp hematoma in front of parietal region. He prepared injury report. He recorded the history of assault. He stated, as per patient, she had been frequently assaulted by co-passenger Durga. Full stop. On that day, Durga poured irritating liquid in her eyes. She was pushed from the train. He proved the injury report. PW9 is the PM doctor. He proved the PM report. He opined death was due to injuries, antemortem in nature. আচ্ছা PW10 যেটা বললে না treated, he opined that the nature of injuries found in the bedded ticket, he proved the bedded ticket. He stated nature of injuries found on the patient could be if she is pushed from the train. PW13 is a police officer attached to Mondir Bazar police station. He shifted he deposed that he shifted the body of the lady to Diamond Harbour Hospital for inquest and starting unnatural death case. PW15 held inquest over the body of the deceased. আচ্ছা ওই PW16 এই 14 বলেছি তো 13 এর সঙ্গে PW16 শিফট করেছিল. PW17 is the investigating officer. He deposed during investigation. He visited PO, prepared Raj sketch map. He examined witnesses. He visited the nursing home where the victim was admitted. He recorded her statement. He collected medical report. In full stop. After the victim expired, he collected inquest and PM report. He submitted charge sheet. Ms. Mitro, for the appellant, submits the victim had not disclosed victim had implicated one Durga as the person who assaulted her and put irritant in her eyes. Her statement, victim in her dying declaration, implicated one Durga. The dying declaration runs counter to the prosecution case against the appellant. Hence, he ought to be acquitted. Mr. Pitashok Banerjee contends appellant was also contends that PW3, a co-passenger, identified the appellant as the person who had pushed the victim out of the pushed the victim from the train. She was detained. She was detained by by the railway police, and she was detained at the spot, detained and arrested at the spot. During 313 examination, now, nowhere during trial did the appellant take the defense that she was not, that she was not known as, take the defense that Durga was, according to you, Durga is this lady. According to this, Durga is the lady.
No, my lord, there is no evidence on record.
They have not.
Their version will not absolve you from leading evidence.
But he has been arrested from the spot.
That is another thing. But it's not your case that it is Durga.
My lord.
At no acha, accordingly, he prayed for acquittal. I have considered the rival submissions in light of the evidence on record. Evidence of witnesses include evidence of witnesses, particularly PW3 and 4, who are co-passengers, leave as well as the.
No, PW4 is not a co-passenger. PW3 informed PW4 that your PW3 is a co-passenger.
PW3 had intimated,
but did not divulge the name who has pushed.
PW3 reported the incident to PW4. The said witness has corroborated his version. PW3 is the from the evidence on record, but from the evidence on record, particularly that of passenger PW3 and the medical officers PW 9 and 10, who held PM report or who held PM report and or medically examined the deceased at the nursing home. It clearly establishes that the victim had been pushed from a railway compartment at Joynagar railway station and suffered severe injuries. Consequently, she died. Consequently, she died. Issue which falls for decision is, did the appellant push the victim? In this regard, PW3 is the most vital witness. He was in the compartment when the incident occurred. He deposed that Padmavati had been pushed by a lady whose name he did not know. The lady was detained at the police station. After the incident, the lady was detained and handed over to police. Evidence, he informed the matter to PW4, who has corroborated his version. As PW3 was unaware of the name of the lady, he could not report her name to PW4. This does not improbabilize his version. On the other hand, his version is corroborated by the detention, by the appellant's detention at the place of occurrence. Full stop. PW in the FIR at the place of occurrence. After detention, name of the appellant transpires and PW5 recorded her name in the first information report. During TI parade examination, PW3, the eyewitness, identified the appellant. He identified the appellant, which corroborates his identification during trial. Ms. Mitro has relied on the dying declaration, wherein name of one co-passenger Durga transpires, but not the petitioner, but not that of the petitioner. For better appreciation, the dying declaration is set out herein below. Full stop. A scrutiny of the dying declaration would show that the petitioner stated that she was frequently assaulted by some person, including a co-passenger named Durga. On the date of incident, Durga assaulted and poured, and Durga and her associates sprinkled irritant in her eyes. Then she was pushed on the platform. She was pushed from the on the platform from the running terrain. A clinical a dissection of the said statement would show that Durga and others had show on the fateful day, Durga, a co-passenger, Durga and others had harassed the deceased, a victim. Durga sprinkled irritants in her eyes. Thereafter, someone pushed her from the train. The victim, due to the attack, the victim was incapacitated and naturally could not identify who had pushed her from the train. This act was seen by the co-passenger PW3, who, in no uncertain terms, implicates the appellant as the person who had pushed her from the train, indicates the appellant as the person who pushed her from the train. As PW3, at that time, PW3 was unaware of her name, was unaware of the identity of the appellant's identity, and could not give out her name. At the station, the appellant was detained, and thereafter her name came out, which was recorded in the first information report. the dying declaration the dying declaration does not run counter to the role of the appellant as narrated by PW3. Accordingly, I uphold the conviction and sentence of the appellant.
Indeed.
Yes, next. Now you will go and have another bout of lunch.
#61, I am for the appellant number 4, my lord. My lord, is a change brief, my
61 is appellant, only one. I am appearing for the.
Everyone is taking away your brief after you are designated.
My lord, I have reached to a point in the pilot.
See, she is there now.
Well, okay, sir, I could not appear that.
So you could not appear, what can be? She will do now. Not today. Not today. What is she saying?
She is in the
Next matter.
My lord, I think there is some misinformation, my lord.
Very good, thank you. Yes, next matter.
61 ki wala?
Both of you can appear. You and Mr. Mondo. Is it permissible? No, I don't think. Legally, but
I got bill.
oh, you do not bill. As is Mr. Mondo.
I never raise any bill.
Then nobody bills.
Yes.
No difficulty. Only Kishan bills.
No.
I'm not in the panel.
Then have Kishan's name in the pen. Why? Senior advocate does not require now. Legally. You don't need any aid now.
Well, today since Malad is in a lighter mood, may I share something?
About him. Most of the things about him cannot be shared in court.
Something that I
You have met Justice Basak. Or you are afraid of meeting him now.
want to share.
So we 62.
66, my lord. I'm very sorry. It is 62, not 61, my lord.
Yes, 62.
And I'm appellant.
I have one of the applications Malad, for one petition. Appellant Malad, he was in custody for 8 years and he's been suffering. There's various ailments and he's being hospitalized. So Malad, I filed a
suffering, but now his condition is stable and he's better.
He's 79 years old. And
My lord,
You are for whom?
I'm for appellant number 4,
What is the name?
Mansura Mondol.
What is HTN and T2DH?
Mansura Mondol.
Mansura Mundo.
Mansura Mondol.
Hey, this Mansur.
We have produced the report of Medical officer, Midnapur Correctional Home. I am for Umar. We direct the superintendent Midnapur Correctional T2D. What is HTN? Hypertension.
Well, he is diabetic, that is type 2 DM is
Let us do like this. Superintendent Correctional Home is directed to send the appellant for medical evaluation by a consultant attached to Midnapur Medical College and Hospital.
I had reached them under Right to Information Act, and this is the report that has been sent by the medical officer.
Let them get a report, consultant, and report be filed on the adjourned date, adjourned 2 weeks. This is which appellant here? Appellant number 1 applicant. Your which application, madam? CRAN 1 এ হচ্ছে।
My lord, mine is CRAN 3.
We are not considering them now. We are just adjourning it.
My lord.
Let us see the health condition of Mrs. Ghosh's client. Thereafter, we will. Yes, report is kept on. Yes, next matter. 63.
10 years, 7 years, 3 months suffered, my lord. 7 years, 3 months already suffered.
But I'm for the appellant in 65. 7 years, 3 months out of 10 years. We have already undergone.
When was the conviction is in 24?
Convict 10 years. Imprisonment is
So you will get a prize for conviction.
10 years imprisonment.
Lower court records have come. Wait for 2 months. Lower court records we called for adjourned 2 weeks after vacation. 24 conviction, 24 bail. Price for conviction.
Well, sample was drawn on the spot, my lord, not after magistrate. Even, my lord, the 52 application has not been accepted by the magistrate court, my lord. Kindly see, my lord, once. The sample. Non-complied.
On the entire, no, it was not produced. Additionally, my lord, 2 independent witnesses. Yes, and then, my lord, the continuous custody of the seized articles, that is also questionable. কোনো ডেট হচ্ছে কোনো ডেট বললো আচ্ছা ওকে আফটার
10 years. Mother is asking conviction. Imprisonment is 10 years.
That is why we are calling for the record. If you are able to satisfy us, we actually look back. The trial judge confidence and next year,